It's not just the tear gas and the batons that federal officers are using when they come out of the Hatfield courthouse to push back protesters. As we've been mentioning a couple of times, unidentified federal officers have also been arresting people, sometimes away from federal property, by pulling them into unmarked minivans and then speeding away. Now, you might have seen the videos either on TV or on social media. Well, the Department of Homeland Security claims that this is a lawful act. Well, Harvard law professor Andrew Crespo says no. He says it is, quote, a textbook violation of the Constitution. So listen with us for a couple of minutes as Crespo explains why.
What is going on? We need to know. Who are you? NLG will get you out. What's your name? Tell us your name.
What's your name?
Okay, you're fine. We'll get you out.
Bro,
We got you, friend.
We got you.
Many people have seen the video of this van encounter in which two camouflaged federal agents approach a man on the street and put him in an unmarked van and drive away.
You just violated their rights.
Kidnapping people.
You just violated their rights.
At the press conference this week, a reporter asked Acting Secretary of Department of Homeland Security, Chad Wolf.
The question that I think many people have is, what exactly is going into those investigations? What level of probable cause are you getting? Because some people are saying...
Secretary Wolf turned it over to Chris Klein, Deputy Director of the Federal Protective Service.
The 40 U.S.C. 1315 authority does allow us to do investigations both on and off the property based on a crime occurring or an alleged crime occurring on federal property.
The Federal Protective Service, until a few weeks ago, was a little-known entity that many Americans probably hadn't heard of. But it's now at the eye of the storm. When Director Klein takes the microphone, he says to the reporter, "You're probably talking about the van."
They asked the individual, please get in the van, and they did take them to an area that was safe for both the officers and the individual to do the questioning.
The agents, Klein says, were interested in the man in the video because earlier they'd seen him in, quote, a crowd and in an area, end quote, where someone else was aiming a laser at the eyes of officers.
So it's not a custodial arrest. We need to question this individual to find out what their role was in this laser pointing.
I don't know if shining a laser at someone is a federal crime. It doesn't matter. We've all heard the saying that people shouldn't be treated as guilty by association. Well, that's also the law, as the Supreme Court said in a case called Ibarra v. Illinois back in 1979. Using a phrase that will stick in your mind, the court said, a person's mere propinquity to others independently suspected of criminal activity does not, without more, give rise to probable cause. In other words, standing near someone who the police think committed a crime doesn't mean that they have probable cause to arrest you. Klein goes on to say that the agents followed the man in the video, who again, they had no basis to arrest, to a calmer location away from the courthouse because they wanted to question him. So far as the Fourth Amendment goes, if that's all they'd actually done, there wouldn't be an issue. The police are allowed to walk up to you and question you in a consensual encounter, so long as a reasonable person in your shoes would think it's okay for you to walk away. These agents might have planned to execute one of those quote-unquote consensual encounters, or maybe not. But in any event, it doesn't really matter, because Klein admits, and the video is clear, that they did something very different. They forcibly removed the man from the scene. And again, not because of anything he did. According to Klein,
but as they approached him, they noticed that coming in their direction were violent demonstrators that now see what's going on and they want to go help. So they asked the individual, please get in the van, and they did take them to an area that was safe for both the officers and the individual to do the questioning.
Klein doesn't say explicitly where they took the man, but we know from other reporting that another person taken off the street in similar fashion, a man named Mark Pettibone, was taken inside the federal courthouse. And Klein does explicitly say that the man he's describing, the man from the van video, was questioned for approximately 20 minutes, something that these officers were unlikely to have done out on the street, given that they were apparently afraid of the surrounding crowds. And then, after those roughly 20 minutes, the agents, quote-unquote, released the individual. Why? Klein explains.
The individual was with the CBP officers for less than 20 minutes while they did the questioning. They had to get out of the area so they weren't attacked. And then they conducted the questioning and they released the individual because they did not have what they needed. The U.S. Attorney's Office is consulted on every engagement that our officers are doing. The U.S. Attorney's Office...
They released the individual because they did not have what they needed. At some point, government lawyers from the Department of Justice show up and apparently say to the agents, "You got to let this guy go. You have no lawful basis to detain him." Translation: they didn't have probable cause when the lawyer showed up. They didn't have probable cause when they put the man in the van. They never had it. And they aren't saying they did. This isn't one of those law school exam types of cases where you're supposed to say, well, maybe he was arrested. This is one of those bar exam types of cases where they ask you, was this an arrest? A, yes. B, no. The answer is yes. The Supreme Court made this clear in a case called Dunaway v. New York back in 1979. In that case, it considered whether the police violated the Fourth Amendment when, without probable cause, they took someone, quote, into custody, transported him to the police station, and detained him there for interrogation. That is an arrest, period. So, the most troubling part of Director Klein's statement is actually not when he acknowledges the lack of probable cause. It's when he says that he thinks this was all legal and perfectly constitutional because, to use his words, it was, quote, a simple engagement.
It's not a custodial arrest. We need to question this individual to find out what their role was in this laser pointing. And unfortunately got kind of spun out of control with the rhetoric about what happened. It was a simple engagement. The individual was with the CBP officers for less than 20 minutes.
That statement is glaringly wrong. It's been glaringly wrong since at least 1979. Let that sink in. The person in charge of this newly beefed up paramilitary federal police force doesn't know what an arrest is. It means he doesn't know when they're violating the Fourth Amendment, like they unquestionably did here. And if the deputy director of this new federal force will say on national television that what these officers did was legal because, quote, this wasn't an arrest, that raises serious concerns about what his officers are doing out on the street, when the cameras are on and when they're not.